Thank you, Mr. President. This time I call up Senate File 591 with Senator Garrett, or 571 with Senator Garrett.
The senator from Polk, Senator Whitford, calls up Senate File 571 with Senator Garrett. The chair recognizes the senator from Warren, Senator Garrett, for opening remarks on Senate File 571.
Thank you, Mr. President. This bill has to do with joint physical care in a dissolution where there are children. Currently, the typical arrangement is the parties get legal custody of the children, but typically one parent gets primary physical custody and the other parent gets visitation rights. This bill would create a presumption that if you have joint legal custody, you would also have joint physical custody. And it's got provisions in it as to how the court goes about determining that. Abuse or neglect, for example, would be reasons for not granting joint physical care. One other thing I want to make clear, because there seemed to be some confusion in the committee process, the standard that the court looks at will still be the best interest of the children. That's the current standard, and that will continue to be the standard here. This bill just sets out some items as to the sorts of things the court will look at to determine what's the best interest of the children.
Sorry, Senator, there's a lot of chatter in the chamber. Can we please have some quiet to let the senator from Warren continue his opening remarks? Thank you.
Thank you, Mr. President. Mr. President, there is an amendment.
There is an amendment. The chair calls up Amendment 5070 with Senator Garrett. The chair recognizes the senator from Warren, Senator Garrett, for opening remarks on Amendment 5070 to Senate File 571.
Thank you, Mr. President. The amendment contains several, basically just technical changes, citations of a year from 2019 to 2020, and re-letters some of the provisions in the bill. Mr. President, those are my opening comments on the amendment.
Is there discussion on the amendment? Seeing none, the chair recognizes the senator from Warren, Senator Garrett, for final remarks on Amendment 5070 to Senate File 571.
I'd move the amendment.
The senator from Warren moves the adoption of Amendment 5070 to Senate File 571. Those in favor say yea. Yea. Those opposed say no. The yeas appear to have it. The yeas do have it. The amendment is adopted. That disposes of all the amendments. We are now back on Senate File 571 as amended. Is there further discussion? The chair recognizes the senator from Lynn, Senator Hogue.
Thank you, Mr. President and senators. I rise today in opposition to Senate File 571, and I'm going through my notes here and trying to get ready for this debate, and so just bear with me as I make a few points. First of all, let me just say this. Iowa already has, I think, really the ideal law for child custody decisions. What current law says is the court will hear the evidence and act in the best interests of the child. And for those of you who have been around the legislature for a while, you may recall legislation in 2003 or possibly it was 2004. It was my first term down here that was passed and signed by Governor Vilsack to eliminate any presumption against joint physical care. And now this legislation would undo that situation that we've had since 2003 or 2004 and replace it with a presumption in favor of joint physical care, and in addition to that, use a standard that would say you can only rebut that presumption with clear and convincing evidence, which I might add is the same evidentiary standard that is used for fraud cases. So this is a much higher standard for trying to rebut a presumption of joint physical care. Nationally, Iowa is recognized as having one of the fairest systems currently for parent rights in the country. This would put us more extreme than any other state in the country. Advocates also often point at Kentucky as the law that is the most pro joint physical care, 50-50 joint physical care state in the country, and it does have a presumption, but it only requires a preponderance of the evidence to undo that, not the clear and convincing fraud-like standard that is applied in the bill in front of us. Another thing that concerns me about this bill is it expressly says that child abuse or neglect relative to the child is sufficient to rebut the presumption in favor of the awarding of joint physical care. That's on, and I don't believe that was amended by Senator Garrett's amendment, but that's on page 4, lines 28 through 31. First of all, I just want to remind people that's child abuse or neglect relative to the child. Doesn't include child abuse or neglect regarding other children, doesn't include domestic abuse. And courts looking at this will say, well, since the legislature highlighted this one circumstance, that other factors that may have ordinarily convinced a court to rule against 50-50 joint physical care won't be sufficient for a court to do that. So we're setting up a system that one form of abuse relative to a specific child is singled out, and we combine that with the clear and convincing fraud-like standard. Now, some of you may hear that and think, well, that's not so bad because parents should have equal parenting time. And when you make that statement, you might be thinking of a marriage like Ward and June Cleaver. And maybe the beeve is 12 or 13 years old, and you might think, well, in that circumstance, something happened, irreconcilable breakdown of the marital relationship between Ward and June, and it's going to be okay in your mind for Beaver to spend 1 week at June's house and 1 week at Ward's house. And to me, I would think that Ward and June Cleaver, under current law, if they were getting divorced, probably could work it out and make sure that both parents had the maximum involvement in Beaver's life, which is what we want. But that's not what this bill is about. This bill applies to custody cases in the dissolution of marriage. It also applies to the custody decisions when the couple is not married. It would apply in the situation where you have a man who is a serial impregnator and has kids with 3, 5, 7, 12, 16 different women. Kind of your classic drive-by dad who is impregnating lots of different women, and here we'll be able to go into court and say that there's a rebuttable presumption that he gets shared physical care with the mother who gave birth to the child after a pregnancy of 9 months, even when they're never married. Even when they're never married. And you're saying with this bill that serial impregnator is going to have a very, very strong legal claim from the day that child is born to 50-50 joint physical care. I believe if you support strong family values, that the correct vote is to leave the law the way it is, which is the best interest of the child without any presumption one way or the other. Now, look, I know that you have constituents who have maybe said, you know what, I feel cheated because I'm not getting the physical care opportunity I want with my child from the custody decision. I acknowledge that courts aren't always perfect. Courts still aren't always going to be perfect. And this legislation says, basic rule, serial impregnator gets equal time with the mother who went through 9 months of pregnancy, gave birth to the child. Maybe the dad wasn't even there. Maybe the mom didn't even want the dad there. And you're saying that dad has a presumption of joint physical care that can only be rebutted by clear and convincing evidence, which, by the way, we're going to look at it and say, well, is he a child abuser of this child? If not, presumption gets even stronger. I'm asking you today to stand for good family values and leave the law the way it is. Whatever you envision about Ward and June Cleaver, back Senator Schultz, when you think America was great, right? Let's go back to the 1950s when America was great. If that's your vision of what's at stake here, that's not in accord with the reality of where our children are being born today in Iowa. So I would hope that this chamber could consider this legislation, make the vote for the strong family values, let the judges make those tough decisions, solely guided by the best interests of the child, which is what the law currently today is, rather than some extreme, legislatively mandated presumption that's going to say that presumption is going to rule unless you meet a fraud-like standard of evidence. I urge you to vote no on Senate File 571.
Seeing no further discussion, the chair recognizes the senator from Warren, Senator Garrett, for final remarks on Senate File 571 as amended.
Thank you, Mr. President. Senator Hogue, you must be reading a different bill than the one I'm reading here. I didn't go into a lot of detail, but I guess I will now since you've made all these extreme claims. Folks, I've got the bill right here. Now, keeping in mind what Senator Hogue was claiming this bill does, let me read from the bill. These are factors that the judge is to consider in determining whether joint physical custody is appropriate and whether that's in the best interest of the children. Okay. Whether each parent would be a suitable custodian for the child, that's first. Some of those parents Senator Hogue was describing probably wouldn't meet that criteria. Here's another one. Whether both parents have actively cared for the child before and since separation. Well, that sperm donor you're talking about, I doubt he'd qualify. Excuse me. He'd qualify under that provision. Another one. Whether the safety of the child, other children, or the other parent will be jeopardized by the awarding of joint custody or by unsupervised or unrestricted visitation. So you take into account the safety of the children. Here's another one. whether a history of domestic abuse, as defined in Section 236.2, exists. You must have missed that. You said domestic abuse wasn't in here. Well, it is. And there are other provisions too, but those are the ones that Senator Hogue obviously missed when he read the bill. So all these concerns that he was raising are covered. And I think most of us would agree it's best if children have good, close relationships with both parents. That ought to be the rule, unless there are extenuating circumstances, and if there are, the judge can rule differently. So with that, ladies and gentlemen, I move the bill be read for the last time and placed on its passage.
The senator from Warren moves that Senate File 571 as amended be read for the last time and placed on its passage. Those in favor of the motion say yea. Yea. Those opposed say no. The motion prevails. The secretary will read.
Senate File 571, a bill for enacting the wording of joint custody and joint physical care being enacted by the General Assembly, State of Iowa.
The senator from Warren moves that the reading thus far be considered the last reading of the bill. Those in favor of the motion say yea. Yea. Those opposed say no. The motion prevails. Is the title agreed to? Yes. The title is agreed to. The question now is, shall the bill pass? Those in favor of the passage of Senate File 571 as amended will vote yea. Those opposed will vote no. The secretary will receive your vote. Senator Johnson votes yea. Senator Edler votes yea. Senator Whitver votes yea. Senator Smith votes yea. Senator Rosenboom votes yea. Senator Quirmbach votes no. Has every senator voted? Every senator has voted. The secretary will close the voting system. The secretary will lock the voting system and record your votes. The Senate will pay attention to the result of the roll call. Those voting yea, 30. Those voting no, 18. The bill, having received a constitutional majority, is declared to have passed the Senate, and the title was agreed to. The chair recognizes the senator from Polk, Senator Whitver.
Thank you, Mr. President. I ask unanimous consent to immediately message Senate File 571.
The senator from Polk, Senator Whitver, asks for unanimous consent to immediately message Senate File 571. Seeing no objections, so ordered. It is now that time of the day for points of personal privilege. Are there any senators seeking the floor? For what purpose does the senator from Lynn, Senator Hogue, seek the floor?
For a point of personal privilege, Mr.
You're in order,
President.
Senator.
Thank you. And again, under the brilliant rule that you allow points of personal privilege after the closing arguments on a bill. Senator Garrett, what you said might have made sense except for the fact on page 4, lines 28 through 31 of the bill, you single out child abuse or neglect of the child who's subject to a custody decision as being, quote, sufficient to rebut the presumption in favor of the awarding of joint physical care by itself. By implication, that means all those other factors that you read aren't sufficient by themselves to rebut the presumption. So you go into court and you've got some claim, you've got some belief, oh, I'm going to win this. I'm going to rebut it by clear and convincing evidence because serial impregnator has not been a very good dad so far. Well, your bill tells the court that's a factor you can consider, but by implication it says that alone is not sufficient to rebut the presumption. And remember, that's a clear and convincing standard. So it would have been a much better bill if you just said, yeah, all these factors can be considered by the court. I still would have disagreed with it, because why create a clear and convincing standard? But when you write legislation, it actually matters what it says. And you are giving a green light to courts across Iowa, if that bill becomes law, to say, I don't care if you're a serial impregnator, I don't care if you have a history of domestic abuse, the legislature has already singled out child abuse and neglect of that child. So I read it, I saw how you had singled out that factor. And when you single out one factor, you diminish all the other factors. So I hope the House of Representatives doesn't take that bill up, Mr. President, and I appreciate this opportunity at the end of the day to continue the argument over the bills that we've just addressed. Thank you, Mr. President.